Well, my name is Gay Cox, and I am a family lawyer from Dallas, Texas. I've practiced family law for over 30 years and am board certified in family law. The first part of my career, I was a litigator in child custody litigation, and then felt after a time that that was tantamount to being a part of an emotionally abusive process. I began to think that we were doing more damage than good with the families. And so in 1990, I switched my practice to exclusively non-contested cases and cases where I was the mediator, family mediation, and did that until 2000. And then one day, a man in our community who was associated with John McShane brought collaborative law to Texas. John's story was that he heard about it at a conference in, I guess, Ireland or somewhere where Pauline Tesler spoke. Well, his partner called me up and said, could I have lunch with you one day? And I said, fine. We went about a block from my office, and I can remember the table we were sitting at when he said, Gay, I have found a way that you will practice law again. And I'm going, not gonna happen, not going back to that again. And he said, no, let me tell you what it is. And he laid out what collaborative practice was all about, because he and John had gone to California and done some training. And it was a moment of epiphany. I immediately knew, yes, what I'm missing in this lonely mediation world as the mediator is that I miss the connection with clients and being there side by side with someone who was going through this. And so I said, yes, that could be something I want to do again. And that meant that I went to the first training in Texas and became a part of the first practice group in Texas. I believe that blessed are the peacemakers, for they shall be called the children of God. And therefore I think that everything we do on this earth to make peace more probable is the work of those people who see themselves as being made in the image of the divine. I think in terms of, I like to do genealogy, okay? And on 3 different tracks of my family, we go back to Charlemagne, but you probably go back to Charlemagne. Everybody goes back to Charlemagne. He was prolific. But those people were warriors. And if I go through my family tree, we're talking about people who died violently or who were in war. And that was the paradigm for how to resolve conflict. I think about how within our country's history, we had statesmen dueling to solve problems. That's just insane. One of you is going to die. And then I thought, well, they've got, before that it was probably trial by joust or combat or fire or something. Well, now we have trial by adversaries in a courtroom, neither of whom is telling the full truth. That's the point. They're shading it to the view of their in the light most favorable to their client. They're not telling the whole story. And no witness that gets on the stand ever gets to tell the truth, the whole truth, and nothing but the truth. The whole truth isn't even what we want them to tell. We want them to tell the truth that supports their position. And so I see that as just one more step toward more civilization and maybe a little more. We're not killing people to resolve the problem in that situation. But we're nowhere near peace. And we're nowhere near peacemaking there. I think there's an evolution going on in how conflict is resolved. And collaborative law fits into that, but so does mediation and other dispute resolution processes. And I do believe that ultimately, well, okay, maybe I have a bit of a feminist trend in me as well, because I believe that when women, who now represent 50% of the law schools, when women sit at the table, the conversation changes. And I think we do think about the fact that, well, I'm the mother of a 23-year-old son. We do think about what conflict can cause for our children in the future and how to make this world a better place. We're going to have to find a way to sit down at negotiating tables and solve problems. It's all about solving problems. And so I'm thinking that I'm just having one little tiny speck of a part, a grain of sand, in what's happening everywhere as this paradigm shifts, and it will continue to do so because we're too much of a global world, too many people on this planet to keep blowing everybody up. I guess one of the first things that happened was that in our practice group, Larry had heard about Medicine Hat and knew about the wonderful practice tools and notebooks and things like that. And he suggested that Carla Calabrese and I work on setting up some practice tools in Texas, particularly for our practice group. Could we start thinking about some agenda examples and some examples of checklists and things? And so we did. We went to the table and started saying, how would we want to do this if we in a best practice manner, and we started developing those. Well, Carla, the work became known at the Collaborative Law Institute of Texas level, and Carla was asked and suggested that I join the committee of the Protocols and Practice Aids Committee. And we first went to a meeting, all excited about participating with these practice tools that we thought would be so helpful in Texas. Harry Tyndall is the one who had the idea of doing this committee. And Harry sat through the meeting in my office in Dallas. He's from Houston, quite puzzled because this was not what he had in mind when he came up with the idea of the committee. He heard all that and then he goes, that's not what I meant. I meant protocols. Well, he didn't get what he was talking about, and he didn't get what we were talking about. There were probably 5 or 6 of us at that meeting, and he went back to Houston and basically wrote the table of contents to the current Texas protocols and came back to the next meeting and says, this is what I meant. We can talk about those other things later, but until we have a basic common set of guidelines of what we want to do together, and we're all on the same page about our values there, we really don't need to be talking about those checklists. We can get to that later. So that started a very long, probably year-long process of just working through the protocols. And in that process of coming up with truly a common set of approaches or more guidelines of what's important in this process, and those protocols are still used in their original form in Texas these many years later. And yes, after we got through doing that, we were given the task of moving forward, and now let's do a participation agreement that looks like that, and let's do some practice aids, and that grew to a very large part of what Clitex offers its members are these very valuable practice tools. And that has continued. I understand as of this year that they're restructuring at the board level, and that I've been asked to chair a committee, and Carla will work with me and others on developing a participation agreement that now conforms to the Uniform Collaborative Law Act. And so then we'll kind of revisit the whole issue, everything from start to finish again, from that perspective. And they told me I have a year to get that done in. And that's good because it's a very tedious process. We went many, many trips back and forth between Houston and Dallas, overnight trips, 2-day working sessions, coming up with the protocols and aids we have now. And I anticipate a bit more with this new process. And then what's changed is at the board level, there will be a policy committee, policy and protocols, made up of board members only, and they will look at the work product and pass on it as to whether or not they want the Clitex to approve those documents. But that's been very exciting to see those materials used statewide. So when you come to the table, you don't have to negotiate what you're going to sign, what you're going to do, how you're going to do it, in what order. It's pretty well the procedures for you are in place, and from there you can just begin to represent your client in a safe environment without having to negotiate process as you work on the substance of the case. So I'm very excited about that initiative.